Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to this special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Situsa and I'll be hosting you for today's important discussion, Adjustment of Status and Family-Based Visas in 2026. Fiancé versus marriage pathways. Now, in today's immigration condition, individuals pursuing family-based immigration are often faced with an important decision when bringing a partner to the United States. Choosing between a fiancé visa and a marriage-based pathway can affect timelines, documentation requirements, and how the case progresses from the very beginning. For many couples, careful timing, proper documentation, and a clear understanding of how each pathway works in practice are essential. Now, the route selected can shape how the case moves forward and what steps will be required along the way. To help us break this down, we're honored to be joined by attorney Henry Haddad, a California-based immigration attorney with over 35 years of experience representing individuals and families across a wide range of legal matters. As an immigrant himself, he understands the challenges clients face and provides clear guidance through the immigration process. Attorney Haddad, thank you so much for joining us today. We're thrilled to have you for this important discussion.
Well, good morning, everyone. Thank you for having me, or good afternoon, whoever you may be.
Now, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or any other platform, are welcome. Please subscribe and share this session with anyone who may benefit from understanding fiancé and marriage-based immigration pathways. Now, Attorney Haddad, let's dive right in. What is the key difference between the fiancé visa process and marriage-based immigration?
The fiancé visa process is, think of it as a two-step process. You bring your fiancé to the United States, you petition for him to come in, and then once they come in, they have 90 days within which you have to get married. Once you get married within that time period, then you can apply for adjustment of status to make that person a lawful permanent resident. The requirements are you must have met your fiancé within 2 years before you file the petition, and you must have physically been present with your fiancé. So it's not enough to meet someone online and say, yeah, I want to petition you. Oh, hey, you're great. I'm going to bring you here to the U.S. So if you meet someone online, you have to travel to their country. If you're a U.S. citizen, obviously, travel to their country, meet them, take photos, meet the family, and so on. And then when you come back, you can say, okay, now I can file a fiancé visa. Marriage visa is a little bit different. You must have been married. Obviously, you'd fly, you'd go to the country of your spouse. You get married, you come back, you file as your spouse. So that's a difference there.
All right. Now, in what situations would a fiancé visa be better or be the better option for a couple?
I think one is a non-immigrant issue. You're not too sure if you want to get married. So you want to bring your fiancé here to see how he or she can acclimate to the U.S., to your environment. And sometimes it's a little bit quicker, meaning the processing period is a little bit quicker than just the marriage. So you want to take your time. You're not in a rush. You don't want to just get married to start the paperwork. A lot of people don't want to just get married for that purpose. They want to know the person and have them come here and see how they are. Now, the problem is if you don't get married within the 90-day period, then the person you're bringing here, the foreigner, your fiance, will have issues in the future adjusting their status or changing their status or even returning to the U.S. So that's a serious thing. So you have to have a serious commitment no matter what.
All right. Now, when is it more practical to pursue a marriage-based green card from the start?
Well, obviously, if you're already married, you're not going to do a fiance visa. You got to do a marriage visa. So
Yeah.
the issue is you got to plan it out because everything takes time now. There's a processing that for a marriage can take 3 to 4 years. There is a special visa you can file to bring your spouse here to complete his or her last steps to become a resident. So on average, I'd say it's maybe a little bit quicker sometimes, maybe a little bit longer sometimes. And it depends on which embassy, which country you're from. Some countries to get an interview, it just takes a long time. Other countries a little bit quicker. So all these things, come into play. Do you have children? What are you going to do with the kids? You have, school issues, school term ends. You don't want to disrupt your children's lives. So every case is different. You have to look at all components.
Yeah. Now, Attorney, how does adjustment of status fit into these two pathways, and when does it apply?
Well, adjustment of status is a process that allows a family member, usually a spouse, let's say, children under 21, or even parents of U.S. citizens or over 21, who have entered the United States, and the legal term immigration uses is admission. They were admitted to the United States, meaning they entered lawfully. And if they're entered lawfully and they have a relative who's U.S. citizen who's willing to petition for them, then they file this petition and application to change the status or adjust the status from a tourist to a lawful permanent resident. That's the process. That can take, it's actually a lot quicker than doing an immigrant visa, and takes between, let's say, 9 months on average, maybe a year. And once you file the petition, your relative can apply for employment authorization in that classification. It's called immediate relative when it's your parents, children under 21, or spouse.
Yeah.
Because I get asked that question a lot. I got married. When do I get my work permit? Well, you have to start the process, and in the application, you request for employment authorization.
Yeah.
There are other family-sponsored categories, like a U.S. citizen applying for an adult child, someone over 21, U.S. citizen applying for a married child, and that application would include the wife and minor children, and a brother, U.S. citizen brother or sister applying for their sibling. In those cases, it's not considered immediate relative, so there's a quota, a time period that you have to wait before the actual processing of the visa occurs. The problem is if you're here in the United States and you have, let's say, a brother or sister wants to apply for you, you cannot remain here because that takes years and years, and you go out of status. Once you go out of status, you're not eligible to adjust your status. Whereas in the immediate relative classification, if you're applying for your spouse, if you're applying for your minor children, if you're applying for your parents, and they go out of status after making a lawful entry, you can still process their papers because that classification has priority. It's immediate relative classification. So keep that in mind.
All right. Now, what are some common challenges that couples face during either process?
One of the challenges is proving the relationship. And that's especially acute for fiance visas, right? So how do you prove that this person's actually your fiance? Typically you're talking about photographs, you're talking about airline tickets, hotel bookings, prove that you are actually there, you visited with the fiance's family, you have a relationship. And same thing with spouses. It used to be just submit a marriage certificate that was proof enough, but not anymore. They want to show, they want proof that, okay, you have a marriage certificate, What did you do afterwards? Are you sending money? Are you communicating with your spouse? What's going on there? So you have to
Mm,
establish a relationship.
yeah, yeah. Now, attorney, how do processing times compare in fiance visas and marriage-based cases?
How they compare?
Yes, how do the processing times compare?
The processing times for a fiance visa tends to be quicker than for an immigrant visa based on marriage to U.S. citizen.
Mm,
Uh, Most people, though, are not aware that if you file a petition for your spouse, now you're married, uh, once you file a petition, you can also file a secondary petition to bring them here sooner so that they can adjust their status. That's
mhm.
it's like two petitions, two applications. But generally speaking, just straightforward fiance visa tends to be a little bit quicker.
Okay.
And the proof for a fiance visa, not only do you have to establish a relationship that she or he is actually your fiance, you have to show proof that you can support them. So it's almost like doing a family-based spouse petition, but with the proviso that you have 90-day period for that person and you to get married.
Yeah, yeah. Now, what should couples keep in mind when deciding which path to take specifically in 2026?
Well, the time lag involved. So if you make plans for a time, many people think, oh, just file for me. I'll be there in 30 days. No, we're talking about a year, year and a half time period,
Hmm.
minimum, if not more. Number one. Number two, uh, issues of prior entries to the United States, issues of visa fraud. We get that a lot nowadays. There's a distinction between material misrepresentation and immaterial misrepresentation. For example, on the visa application, let's say you put, I worked at a school from May 2020 until June 2021, but in reality it was July 2021. That 1 month period is immaterial. But if in your application you fail to mention that you served in the military or you worked as a police officer or in some capacity, you omit it completely, then that's considered visa fraud, and that may cause a denial of your application, even though you might have a
Hmm.
valid marriage, valid fiance, and everything. So you have to be verified. And of course, disclosure of any kind of criminal arrest, convictions, anything that's negative has to be disclosed.
Thanks for those thoughts, attorney. Now, for everyone watching, this conversation about fiance visas and marriage based pathways is not there to create confusion, but to break down how these options work in real cases. Now, each path comes with its own process, its own requirements, and timeline. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is Triple B accredited and ISO certified. This reflects our commitment to transparency, accountability, community education, and security. Now, Attorney Haddad, based on your experience, how does ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
There are always issues in every case. Some things are overlooked. Many people think it's a straightforward pathway. I'm married to a U.S. citizen. I want a green card. But there is a process, and that process nowadays, especially, is meticulous, and every T has to be crossed, every I dotted. And for those people who've had issues in the past, such as perhaps an arrest or a criminal conviction, there are waivers. So you have to know when to file the waiver, at what time, and so forth, because it'll probably cause a slight delay, but it should be filed. But regularly speaking, the people are not aware. They think I'm going to file the form and submit it and get it approved, and my husband or wife will be here within a few months. It doesn't work that way.
Yeah, yeah. Now, before we move into our live Q&A, let's tackle this important question. Now, what are some misconceptions about fiancé visas and marriage based immigration pathways that you believe individuals should clarify early on to avoid misunderstandings?
Uh, disclosure. A lot of people don't want to state that they were married before. They want to misrepresent their employment history, for example, misrepresent the relationship. If you visited, you saw your fiance one time and nothing came of it, they want to state that, oh, yeah, we got engaged. And immigration, USCIS will come back and say, okay, show us proof. We need proof. So just think of this for everything in relationship, whether it's fiance or marriage, you have to back it up with documents. That's the proof that they're asking for, whether it's marriage or fiance. More so for fiance, because historically, a lot of people just say, oh, yeah, they meet someone. Yeah, I'll bring it to US. But it doesn't amount to a real engagement, fiance relationship.
Yeah. If you've just joined us, we've been speaking with attorney Henry Haddad on adjustment of status and family-based visas in 2026, fiancé versus marriage pathways. We are now moving into our live Q&A. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many questions as time permits. All right, first question. What is the main difference between a fiancé visa K1 and a marriage-based green card in 2026?
Well, the main difference is that the fiancé visa, you're requesting to bring your fiancé to the US so that you can marry him or her. Whereas in a marriage case, you're already married and you want to bring your husband or wife to the US. Similar processes, except different timelines, different documentation needed. But one, the marriage case will lead to a green card residency. The fiancé visa, you have to get married first and then go into the husband and wife marriage-based type of petition. So it's more of an additional step involved for a fiancé visa. And if you don't get married on the fiancé visa, then your fiancé becomes ineligible for many things.
Yeah. All right, next question. Which option is faster right now, the fiancé visa or getting married and applying for a spousal green card?
Well, getting married, you have to do logistics, you have to travel and get married to your spouse, unless your spouse is in the US. If your spouse is in the US, then you file an adjustment of status, assuming they entered lawfully, application, so that would be faster. If your spouse is outside the US, I'd say just the standalone would be a fiancé visa. Application would be a little bit faster. But also with the marriage case, you have a secondary application, you can bring them here, but that takes time too. So it used to be a clear cut, within 3 months you'll receive approval and then you'll be set up for an interview, but now things are dragging on and on. So give it a year and a half, maybe even 2 years just for a fiancé visa. Marriage visa could be that length or maybe even longer.
Yeah. All right. Can I apply for adjustment of status if I entered the US legally but overstayed my visa?
The answer to that is yes, but only if the petitioner is a U.S. citizen spouse or a U.S. citizen child who's over 21. So it depends what classification you come under. If it's your brother or sister is petitioning you and you overstayed, you cannot apply for adjustment of status.
All right. How does USCIS determine if a marriage is genuine during the green card process?
Number one, they look at documentation, supporting documents. They look at photos. They look at communications between husband and wife, whether there's been support involved. If they're in the U.S., obviously they'll be interviewed, both of them together. They'll be asked questions, sometimes some personal questions. If it's outside going through an immigrant visa interview, they'll ask the spouse some questions about how they met, where they met, what they know about each other. And obviously, if you don't know much about your spouse, then that's going to be an issue. So you got to be prepared for the interview to establish a relationship. And many
Right.
people get annoyed, why are they asking me when we met? Or why are they asking me if, I know where he or she, whether they're married before and so on. Well, for immigration purposes, you spouse, you must know your fiancé. You got to know.
Yeah. Correct. What happens after entering the US on a fiancé visa? And how soon do I need to get married and apply for a green card?
When you enter the US on a fiancé visa, it's a non-immigrant visa. You have to get married within 90 days of entry. Once you get married within 90 days of entry, you can then apply for a green card, whether that's a month after that, 2 months, 3 months, doesn't matter. The main issue is you have to get married within 90 days, and not just married to any other person. You have to marry to the person who petitioned you to come in on a fiancé visa.
All right. Now, Attorney Haddad, when individuals hear about recent developments in immigration policy or processing, how should they interpret these changes in the context of family based immigration?
They're very strictly applied nowadays. Immigration officers under the current Trump administration are looking for ways to deny your application, deny your visa. So be careful that you're consistent. Whatever application you submitted, even on a tourist visa 10 years ago, 20 years ago, and now you're applying on a fiance or a marriage based. If you're inconsistent, if you state something now you didn't state before, and they'll deem that to be material misrepresentation and deny it on fraud basis, which then requires you to file a waiver. So I'd be very
Mm.
careful. You got to be consistent, and you got to prove your relationship. You have to prove it.
Yeah.
Make sure also nowadays there's
All right. We seem to have lost Attorney Haddad, but we will wait just a minute. He will come back. Attorney? Attorney, can you hear me? I think you're muted. I think you're muted, Attorney.
the employment authorization. On a fiance visa, you come in on a K-1 visa, you're not entitled to employment authorization. So you're not
Yeah.
expected to work. On an adjustment of status, marriage-based application, uh, part of the application would be a request for employment authorization.
All right, Attorney, just to follow up on
I
that
guess I'm
previous
going to be both
question.
the host and the guest. So
Can you
there
hear me,
we are.
Attorney?
We're back on. Okay.
We're back on. Attorney, can you hear me?
Yes.
All right. Sorry. Technology will do that sometimes, but we are back. Now, just a follow up on the previous question, do these developments have any practical impact on how couples approach fiance or marriage-based cases?
That I didn't hear, but the new developments are, yes, they're following the regulations more strictly. You have to prove that you're not going to come to the S and not be productive. You have intent to work, you intend to be productive. You have to have full disclosure, make full disclosure of any unlawful activity, any arrests in your home country. Whereas before it was really just listing your convictions, criminal convictions, if any. But now it's also arrest. You got to be careful, and you have to see which ones, if there's an issue, whether you overcome it with a waiver application, or if it's a material issue that's going to be in the way of your getting your visa approved.
Yeah. All right. Thank you to everyone who joined us for the special edition webinar. And thank you, Attorney Henry Haddad, for joining us and giving us, well, sharing your knowledge and practical guidance with us today. For everyone else, you can always visit immigrationquestion.com to ask immigration related questions, stay informed on policy updates, and register for upcoming live events. If you missed any part of today's discussion, the replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. Attorney Haddad, thank you so much for joining us today. And these things do happen. Connections do, they can be a bit problematic sometimes, but we thank you for that interesting session.
I understand. Thank you for having me. One last thing is, if you have a pathway, whether it's fiance or marriage, go ahead and do it. Don't be afraid. Just know that it's going to be, you have to, that's all.
Yeah.
Good luck to everyone.
Well, thank you. All right. Thank you so much. You heard it from Attorney Haddad. All right. We look forward to seeing you on Saturday. Until then, stay informed, stay prepared, stay connected, and do your homework. Bye-bye.
Thank you.
Thank you so much, Attorney Haddad.